Hey there, welcome to Help Solve the Case. Today we are on the Tyler Robinson case. We are reading the defense brief that has literally just been filed. I just got it online. And this is in response to we had the first part of the preliminary hearing. We are set in about 2 weeks for September 1st for the continuation of the preliminary hearing. Possibly the answer, we're not really sure. We heard what the state said. You can check out that video. And now we're going to hear what the defense says in support of their position on the preliminary hearing. Now, if you don't know, the preliminary hearing is a probable cause determination only. I don't have my measuring cup. And it is not beyond a reasonable doubt. It is just probable cause. Different level of proof, if we want to say that. All kinds of crazy here, but that's all they need just to bind Mr. Robinson over for trial. And of course, I should not need to mention he is innocent until being proven guilty. Let me share my screen here and get myself in the right position here. All right. As I mentioned, this was just filed hot off the press. Basically, this is their table of contents. We're going to start right here. They've got some case law that they're going to cite. They're going to talk about. It's a 41-page document. We'll see how that goes. And what my plan is, I will probably, after we go through this, I will take the state's position and then the defense's position, and I will compare them for you. I think that'll be very interesting. All right. Introduction. On September 16th, 2025, the state charged Tyler Robinson with a capital offense of aggravated murder and other lesser offenses. The state had over 10 months to investigate the shooting death of Charlie Kirk and to develop legally sufficient evidence that Mr. Robinson, quote, knowingly created a great risk of death to another other than Charlie Kirk and the defendant, end quote. The sole aggravator alleged in the information, which in theory exposes Mr. Robinson to the potential punishment of death, and they cite Utah Code 76-5-202, subsection A 2A3. The state's presentation of its evidence as to this alleged circumstance in aggravation, they're talking about an aggravating factor, at the preliminary hearing in July 2026 wholly fails to carry its burden of proof. The state's failure cannot in any manner be attributed to any orders by this court limiting its presentation, nor does it fall within Rule 1102C1 because the state's presentation in support of this aggravating factor was not based upon hearsay evidence, nor did this court exclude any proffered expert testimony. In fact, the court did not exclude any evidence on this subject, and it did not limit the amount of time available to the state to present its case. And just to say, I'm reading this just as you are, and that is, let's be a little confusing right out of the bat. They have aggravated highlighted here. What I'm thinking here is they're trying to talk about aggravated murder and this knowingly created a great risk of death to another other than Charlie Kirk and the defendant. And if you remember, when we were reading the state's copy, they talked about, and I talked about trying to explain it, the trajectory, not only the person that was standing in front of Charlie, they talked about children in the crowd, and they talked about ricochet and all kinds of things, that there were so many people present. There was people behind the tent, next to him, in front of him, and all that stuff. I'm trying to interpret. They hit it very legalese and not a good intro, in my opinion, right here, trying to make it clear. They're saying that the state what they presented, this alleged circumstance in aggravation at the preliminary hearing, does not carry its burden of proof. It doesn't meet the element of the crime. And they're further saying is that the failure cannot be attributed to any orders of the court limiting its presentation, which means it's not that the judge told them they couldn't say something, or does it fall within the Rule 1102C1 because it wasn't based on hearsay evidence? If you remember, they were using those 1102s, those affidavits, instead of people testifying. And it says, nor did this court exclude any proffered expert testimony. Remember, the state put their experts on. We saw the ATF, we saw the FBI, we saw case agents, all right? It says, in fact, the court did not exclude any evidence on this subject, and it did not limit the amount of time available to the state to present its case. Yet, this is the defense talking. The state has failed to establish probable cause that the shooter, quote, knowingly created a great risk of death to another other than Charlie Kirk, end quote, and himself. And also remember, they talked about target practice. Remember, they went and got the targets from the target practice. And they talked about the number of bullets, that there was extra bullets in case of a miss. The state is required, as a matter of law, to show more than a, quote, possibility that someone else may be killed by defendant's conduct. Rather, I think they're supposed to say then, rather that there was a high probability, that's a quote, high probability of that result, and that the defendant knew of that high probability. They're saying that the state has to show more than it's possible, right? In a crowd of people, the wind could come and misdirect the bullet. There could have not been enough gunpowder in there and it could have fallen short. He could have jerked the thing at the last moment. Somebody could have jumped in front of it. He could have been a bad aim. They also talked about the fact that the scope and everything, that the rifle was disassembled, that the sight picture could have been off, all these possibilities that someone else could have been killed, rather than what the defense says, a high probability. And they didn't show that the defendant knew the high probability. I'm just asserting this here. We don't have a text message saying, I'm going to make sure I take a box of bullets in case I hit someone by mistake. We didn't hear anything like that. And that's just my example there. The defense continues, and where the state has overwhelmingly failed to make this showing, it asked this court to expand Utah's narrow construction of the, quote, great risk of death aggravator using decades-old cases from another state jurisdiction. It sounds like they are asking for leeway. It sounds like, I'm not sure the way they wrote it, that they're asking for leeway. They're showing for great risk of death, or what the state did of the great risk of death, using decades-old cases from another state jurisdiction. It sounds like they're trying to tell the court no, but they're asking the court to expand it. I'm not sure. Maybe we'll hear more going on. Binding constitutional precedent, both under Utah law and the U.S. state's constitution, demonstrate the state's failure here and why this court may not impermissibly broaden the scope of, quote, knowingly created a great risk of death, end quote. The facts and the law require this court to strike the sole aggravating factor. All right, let me think. I think I understand where they're going here. They're saying the state has overwhelmingly failed to make this showing, and it seems like the defense is saying that the state is expanding the great risk of death. They're trying to supplant it, to support it by using decades-old cases from another state jurisdiction. That's what it sounds like. And they're like, no. Yeah. And where the state has overwhelmingly failed to make this showing, it, meaning the state, asked this court to expand the definition of great risk of death, the aggravating factor, only using decades-old cases from another state, not from Utah, right? This is the Utah law. This is the Utah statute. So it should be based on Utah principles, although we use other precedents and citations from other court hearings. They're saying, look, again, I'm interpreting here. Y'all knew what you meant when you put it in there, and we don't have any Utah case law destroying it. So y'all know what you meant when you put it in there. They're saying the facts in the law require this court to strike the sole aggravating factor. Here's the argument. I guess that's count one or part one. The state has not met its burden to show probable cause by relying on hearsay deemed reliable by rule in violation of Mr. Robinson's constitutional rights and separation of powers principles. This sounds like it's going to be a doozy. As briefed and argued extensively prior to the preliminary hearing, and as raised as a continuing objection throughout the preliminary hearing itself, the state's extensive use of hearsay deemed reliable by Rule of Criminal Procedure 1102, those were those little affidavit forms, violates Mr. Robinson's constitutional rights and separation of powers principle. And they're referencing the U.S. Constitution amendments and the Utah Constitution Article 1. It says, this is the defense, this court may not bind over Mr. Robinson based upon the state's evidence consisting primarily of hearsay that has not been assessed for reliability. Now, you got things in the court, a confrontation clause and things like that, and they did talk about it during that hearing, and I've brought it up about this fact of 1102s. And it was my understanding, based on what I heard argued back and forth during the preliminary hearing, that the hearsay, while hearsay is not allowed in the main trial, that hearsay in certain capacity could be allowed in the preliminary hearing. I'm not the lawyer. I can't explain that. But here, the defense is, that's what the defense is saying. This is hearsay. And hearsay, we have the confrontation clause that you have a right to confront witnesses against you. And reliable witnesses, you have a right to make sure that information is reliable. Now, I'm going to dovetail a little bit here, talk about Brian Koberger, which we talk about. One of the reasons that I was watching Brian Koberger's genetic genealogy portion was because they could not get the documents. Now, remember, that's a tip. That was information. And information, whether it's a tip or not, needs to be reliable. Where did it come from? How was it developed? How could they confront it? And in the end, I believe, correct me if I'm wrong, y'all that followed it, the defense stipulated to it being the tip. That negates the ability to confront. We also just heard that in the Lindsay Clancy case, where the defense was stipulating for certain things to be entered into evidence and whatever. And if you remember, if you watched it, the judge says, look, Miss Clancy, I want you to understand, you're giving up all these rights. You're giving up the confrontation. You're giving up if you stipulate. There's a lot of things that go along with this, while it seems a little bit vague on the surface. So we're going to keep hearing with what they're saying. The defense right here is saying the court may not bind over Mr. Robinson based on the state's evidence consisting primarily of hearsay that has not been assessed for reliability. How many of those 1102s did we hear? Didn't we hear the ring neighbors? We heard the TPUSA guy. Did we hear the children? Was that the person that supposedly somebody saw something on the roof, or they were a child or something? We saw a lot of those 1102 forms. The defense says this is particularly true as it relates to the evidence cited by the state to establish identity for all of the charged counts. And that looks like maybe a transcript area, not sure, or that's a state exhibit. They say the evidence consists of largely of alleged communications between Mr. Robinson and Mr. Twiggs, alleged communications between Mr. Robinson and other individuals on the application Discord, and an identification of Mr. Robinson from UVU surveillance footage. They're saying states exhibit. So I think states exhibits are the STE Act 16.1, 16.2, and then the defense, they were labeling theirs weird. They were labeling them by the last name. It's a little confusing. This evidence came from or became presumptively admissible through a recorded interview between the Utah County Attorney's Office and witness Lance Twiggs. A witness the court would not allow Mr. Robinson to seek to subpoena from another state to testify at the preliminary hearing. Now that's interesting because we did see a portion of a Zoom call. And I had mentioned that and not to sound derogatory, but I didn't feel that they put the A team on for several reasons, and that they were using the 1102s because anytime you testify, you're on the record in statements, and then you could accidentally or intentionally contradict yourself later on and catch a perjury charge or get impeached or something is going on. The less time that you're up on the stand, a witness is up on the stand, and they could be impeached or cross-examined or challenged, the better that it is. And that's why we had a lot of people, in my opinion, not showing up during the preliminary hearing because it's not, what did I say? You got the second string. You don't have the first string. You got the second string. And you don't want to have all of your star witnesses. You don't want to unveil your entire case during the preliminary hearing, because in the preliminary hearing, you only need, think about our measuring cup, you only need a little bit. You don't need beyond a reasonable doubt. You don't need an overflowing measuring cup, right? You only need a 16th of a cup, an 1/8 of a cup, or whatever. You don't need the whole thing. So this is interesting because this says the court would not allow Mr. Robinson to subpoena Mr. Twiggs to testify at the preliminary hearing. What's up with that? Is it a cost factor? Because the court has to pay for that. How can you not allow a confrontation except if they're saying that preliminary can be done through these 1102s? I'm not sure. Any Utah attorney, please feel free to weigh in. But I did not know that he wanted him to testify as a defense witness and he was disallowed. I don't know how that's going to go down with any PCR, post-conviction relief, or whatever. The state has failed to prove probable cause by reliable evidence that satisfies each element of each of the charged evidence. Remember, we went through that. The court must decline bind over on all charges. Now, I don't know if it's that way in Utah, that if you miss one element, all of them go away. That's a question I'm going to have to ask. All right, let's look at this section. I don't know if that's a 1 or an I. As a matter of law, the state has not established and cannot establish probable cause to support the aggravator, that's the aggravating factor, that the shooting knowingly created a, quote, high probability of death to another individual from the single shot. They make it a single shot there. That's important. Semantics, remember, because the other ones they talked about multiple bullets from a high-powered scoped rifle from a rooftop vantage that hit the intended target. Mr. Robinson is charged with aggravated murder pursuant to Utah Code 76-5-202, subsection 2A3, which requires the state to prove that, quote, the actor intentionally or knowingly caused the death of another individual under circumstances where, quote, the actor knowingly created a great risk of death to another individual other than the deceased individual and the actor, end quote. The state has not shown and cannot show probable cause to support this single alleged aggravator. Now, what came into my mind is I try to give examples. If there was an automatic weapon or a drive-by shooting and somebody, right? Yes, you get free side effects. And multiple rounds strafing, multiple rounds went across, and whether somebody died or didn't, intentionally shooting 20 rounds into a crowded space or a house or whatever, and I'm not on one side or the other here, I'm just saying that would seem to more fit intentional knowing that you could tag somebody inappropriately than one single shot is what the defense seems to be saying. A defendant may only be bound over for trial, quote, if the prosecution produces evidence sufficient to demonstrate probable cause that the charged crimes were committed, end quote. I'm not sure if it's all or nothing. And the defendant committed them. They talk about State v. Murphy, which is a Utah case. State v. Ramirez, Utah Rules of Criminal Procedure 7B, subsection B. It says this threshold requirement is intended to, quote, ferret out groundless and improvident prosecutions, relieving the accused from the substantial degradation and expense incident to a modern criminal trial when the charges against him are unwarranted or the evidence insufficient, end quote. This is my assistant, ChatGPT. I said, in Utah, do they have to prove all the charges at the preliminary hearing to bind over, or can they go on just some? It says they do not have to win every charge at the preliminary hearing. In Utah, the judge evaluates probable cause as to the charged offenses, and the result can be a partial bind over. Under Utah Rule of Criminal Procedure 7B, the state has the burden. The magistrate binds the defendant over when there is probable cause to believe the crime charged was committed and the defendant committed it. So it says, when probable cause does not support all charges, the magistrate can determine which charges are actually supported. And if the prosecution later adds a different offense, Utah Rule 4 expressly gives the defendant a right to a preliminary hearing on that newly added offense. Oh, and Chatty's always on the ball here. One important nuance. The state does not have to prove each charge beyond a reasonable doubt at the prelim. It's a probable cause screening hearing, and Utah permits the probable cause finding to rely substantially on reliable hearsay. Here he goes. If you're thinking about Tyler Robinson's prelim, it's always listening. The useful way to analyze it is count by count. All right. He's too funny. He's too funny, my boy, my assistant. All right, let's go back. All right. As discussed further herein, the state's burden requires them to provide evidence to support a, quote, reasonable belief, and quote, when the evidence considered under the totality of the circumstances is wholly lacking and incapable of reasonable inference, To prove some issue which supports the prosecutor's claim, this court must decline bind over, quoting State v. Prisby. It's a Utah case. The court is empowered to make reasonable inferences from the evidence presented. However, the court may not engage in speculation. They're talking about the United States Constitution and the Utah Constitution both require courts to construe alleged aggravators narrowly. Then the aggravator, they're talking about the aggravation here and the death penalty, right? This aggravator about these other people, the intent to harm other people. And they're talking about, quote, the 8th and 14th Amendments to the United States Constitution do not permit imposition of the death penalty in an arbitrary or capricious manner, end quote. State v. Wood, that's a Utah case, quote, the objective of the law is to require that the discretion of a sentencing body in a capital case be carefully channeled by standards designed and applied to ensure that there is a reasonable distinction between those murder cases in which the death penalty is imposed and those in which it is not, end quote. And it says, for brevity here, Mr. Robinson refers to the aggravator as KGRD throughout. I guess it's great risk of killing, great risk of death, maybe. In order to bring meaning to this longstanding principle, the United States Supreme Court has explained that the Constitution requires courts to narrowly construe aggravating factors in order to avoid, quote, overly broad interpretations that violate the 8th and 14th Amendments. See Gregg v. Georgia. The United States Supreme Court has twice examined the KGRD aggravator at issue here. In Gregg, the court upheld the inclusion of KGRD as a statutory aggravating circumstances. They said, while such a phrase might be susceptible of an overly broad interpretation, the Supreme Court of Georgia has not so construed it. The only case in which the court upheld a conviction in reliance on this aggravating circumstance involved a man who stood up in a church and fired a gun indiscriminately into the audience. See, like I said, spraying, right? Bullet stripe. On the other hand, the court expressly reversed a finding of great risk when the victim was simply kidnapped in a parking lot. That same year, in Prophet v. Florida, the court upheld the use of KGRD as an aggravating factor based on the Florida Supreme Court's decision in Alvord v. State, which also construed KGRD narrowly. In Alvord, KGRD was, quote, obvious because the defendant, quote, murdered two of the victims in order to avoid a surviving witness to the first murder, end quote. The intention was there that they had to kill both witnesses, apparently. In each of these cases, the court considered whether the statutory aggravating circumstance was too vague and too overbroad to pass the 8th and 14th Amendment muster, and in each, the court upheld the aggravator because the state's highest courts had narrowly construed them. The principle that the death penalty may not be, quote, wantonly and freakishly imposed, quote, requires a state to channel the sentencer's discretion by clear and objective standards that provide specific and detailed guidance, quoting Lewis v. Jeffers. They've got a subnote here. Lucas v. State is another Florida case in which the Supreme Court upheld a KGRD judgment when the defendant had engaged in a raging gun battle. That's lots of rounds, right? As a result, a state's, quote, definitions of its aggravating circumstances, those circumstances that make a criminal defendant eligible for the death penalty, therefore play a significant role in channeling the sentencer's discretion. Thus, this court, meaning the Utah court, must narrowly construe KGRD consistent with Utah Supreme Court guidance and strike the aggravator. Utah Supreme Court decisions narrowly construing the KGRD aggravator require this court to strike it here. Over the course of the past 50 years, the Utah Supreme Court has had at least 3 opportunities to carefully consider the KGRD aggravator. That is so hard to say. In doing so, it has identified a minimum set of factual circumstances which must be present in order for the aggravator to be applied in a constitutionally valid manner. Sometimes they refer to these as a step test, a two-step test. We've talked about in some cases that when they have to meet these circumstances, they've got to meet one or two or three parts of it. Mr. Robinson addresses here the three decisions by the state's highest court when, applied to the facts presented here, compel this court to strike the alleged aggravator because those constitutionally required factors are not present. Just as they have to meet the elements of the crime, they have to meet the elements of the precedent in order to use it. The Utah Supreme Court cases are its decisions in State v. Sosa Hurtado. We had heard that one. Two longstanding decisions in State v. Johnson and State v. Pierre. They're addressed below in chronological order so that this court can see how the doctrine, which this court must apply in this case, has evolved to require as a factual matter that where one or more firearms, is used in a homicide, the defendant actually discharges multiple rounds, hitting and or killing individuals other than the murder victim in a series of events. These actions are the, quote, concatenating series of events, which the Utah Supreme Court first referred to in its 1997 decision in State v. Pierre and then reaffirmed in its decision in Sosa Hurtado 2, that may lead the court to conclude that the conduct alleged created a, quote, high probability that someone other than the victim and defendant would be killed. 1 year after this United States Supreme Court decisions in Gregg and Proffitt, the Utah Supreme Court considered the application of KGRD in State v. Pierre. In Pierre, the defendant was convicted of 3 counts of capital murder. Pierre and 2 co-defendants tied up 5 individuals in a business establishment and forced them to drink liquid Drano. Pierre eventually shot each of the 5 victims in the head. 2 of the victims survived, 3 did not. Wow. In upholding the application of Utah's KGRD aggravator, the Utah Supreme Court found that, quote, the evidence fully sustains that the killing of the 3 victims and the creation of a setting of great risk of death to the 2 surviving victims occurred within a brief span of time in which were formed a concatenating series of events. A decade later, in State v. Johnson, the Utah Supreme Court held that the KGRD aggravator did not apply to the circumstance where the defendant attacked a husband and wife with a shovel, killing the man. When the defendant delivered the injuries to the man, he was on the other side of a warehouse from his wife, and there were shelves between them. The court noted that the KGRD, quote, properly applies to situation in which the defendant kills his victim in a manner by which he knows he is gravely endangering others. The Johnson court also held that, quote, the state produced no evidence indicating that wife, who's over here and the husband's over here, was placed at grave risk of death by defendant's battery, nor did it produce evidence indicating that defendant knew that his conduct towards husband placed wife at great risk. If you had a gun, maybe, and it wasn't a great distance, you could shoot, but they said there's those shelves in between, but it was a shovel. Could he have killed her by chucking the shovel from here to there when they were separated? In Johnson, the Utah Supreme Court further explained how KGRD aggravator is applied. It wrote, Section 76-5-2021C properly applies to situations in which the defendant kills his victim in a manner by which he knows he is gravely endangering others. See Chanel v. State. That's a Georgia case. Defendant was convicted under a statute similar to this one, but which also includes language concerning killings in public places when he assassinated his victim by opening fire in a crowded church. State v. McMurdy, Arizona. Defendant shot his intended victims in a crowded bar. State v. Saunier. Defendant made the victims lie on the ground, shot them with rapid fire from a rifle. State v. Doss. Defendant shot victim in a crowded auditorium. A closer look at the cases referenced by the Utah Supreme Court in Johnson demonstrates that the fact patterns which it views as authorizing the KGRD aggravator does not exist here. In Chenault v. State, the defendant was convicted of aggravated murder after shooting multiple individuals inside a church. There, the defendant fired multiple shots from 2 pistols, killing 2 individuals and injuring another, and, quote, randomly shooting into the congregation. I'm giving you some visuals. The jury recommended the death penalty, finding the aggravating factor of knowingly created a great risk of death to more than one person in a public place by means of a weapon or a device, which would normally be hazardous to the lives of more than one person. The Georgia Supreme Court found that the evidence supported the jury's finding. In State v. McMurdy, the Arizona Supreme Court issued a remand for resentencing because the trial court did not adequately consider mitigating evidence in the course of imposing a sentence of death. The facts underlying the conviction were that after McMurdy and 3 victims engaged in, quote, loud discussions in the bar, he went to the parking lot, retrieved a gun, and returned to the inside of the bar where he shot 3 victims, killing 2 and wounding a 3rd. During sentencing, the trial court found that the defendant knowingly created a grave risk of death to persons other than the murder victims. The Arizona Supreme Court agreed because, quote, the evidence at trial established that the ranch house bar was crowded the night of the killings and that there were from 5 to 9 other people in the immediate area of the victims when they were shot. When he emptied his gun at the victims, appellant created a grave risk of death to those other people. The other Arizona Supreme Court decision cited by the Utah Supreme Court in Johnson is State v. Doss. In Doss, the Arizona Supreme Court upheld the application of the KGRD aggravating factor where, quote, the defendant shot the victim in a place crowded with college students, and one of the defendant's shots did, in fact, wound one of those students. There's more than one shot. In the course of the conduct, the defendant emptied his revolver. Under these facts, there was, quote, no question KGRD applied. The last out-of-state case cited by the Utah Supreme Court in Johnson is a 1981 decision of the Louisiana Supreme Court in State v. Saunier. In Saunier, the jury found to be true the aggravating circumstance that the defendant, quote, knowingly created a risk of death or great bodily harm to more than one person. The Louisiana Supreme Court had previously determined that this aggravator, quote, is established when the defendant, by a single and consecutive course of conduct, contemplates and causes great risk to more than one person, end quote, citing its prior decisions in State v. Monroe and State v. Culberth. In Saunier, the Supreme Court found that, quote, the execution of 2 victims lying side by side with 6 rapid rifle shots clearly amounts to a single consecutive course of conduct by which defendant contemplated a great risk to more than one person. In each of these cases relied upon by the Utah Supreme Court in Johnson, the defendant fired multiple shots from a firearm in close temporal and spatial proximity to other individuals, and in each of these cases, individuals other than the murder victims were in fact injured. In 2019, the Utah Supreme Court revisited the standards for imposition of the KGRD aggravator in Sosa Hurtado 2. Looks like that was 2019. In that case, the defendant was charged and convicted of aggravated murder for shooting and killing Stephen. Just prior to shooting Stephen, the defendant fired his weapon at a second individual, Isabel, which resulted in injuries to Isabel. The shooting occurred inside a smoke shop. Sosa Hurtado entered the smoke shop and pulled an assault rifle from his jacket. Sosa Hurtado first fired a shot at Isabel that missed, but shattered a glass case, causing injuries to Isabel. After he shot at Isabel, Sosa Hurtado, quote, turned towards Stephen and fired a shot hitting Stephen's hand. Stephen fell to the floor. Sosa Hurtado then shot Stephen 2 more times, killing him. I just want to read this subsection here. Arizona eliminated its KGRD aggravator in 2019. The lack of KGRD is now a mitigating factor in Arizona. That is, it is mitigating if the quote defendant could not have reasonably foreseen that his conduct in the course of the commission of the offense for which the defendant was convicted would cause or would create grave risk of death, of causing death to another person. The Utah Court of Appeals had below examined the sufficiency of the evidence supporting KGRD. State v. Sosa Hurtado, reviewing Utah case law, specifically State v. Pierre and State v. Johnson, and, quote, persuasive authority from other jurisdictions, the Utah Court of Appeals determined that judicial decisions about whether this aggravator applies are often influenced by three main factors. One, the temporal or chronological relationship between any actions the defendant may have taken towards the third party and the acts constituting the murder. The spatial relationship, we're talking about time, the spatial relationship or proximity, distance, and whether and to what extent the third party was actually threatened by the assailant, either by direct threats or by indirect means, such as the risk of stray or ricocheting bullets. Blah, blah. In upholding the jury's verdict and the Utah Court of Appeals decision affirming the verdict, the Utah Supreme Court found that, quote, a reasonable jury could easily find that the, quote, identified factors support the conclusion that Sosa Hurtado caused a great risk of death to Isabel during the murder of Stephen. Sosa Hurtado fired at Isabel seconds before shooting Stephen. He shot at Stephen when Isabel was close by, and he specifically acted with the intent to harm or kill Isabel. In doing so, the Utah Supreme Court endorsed the, quote, concatenating series of events formulation it first identified in Pierre. In order to satisfy the aggravator, there must be acts in a series that are linked together in a meaningful way. What they're saying here is only one bullet. It wasn't like one hit and one missed and 12 were fired or anything. They're only saying one bullet. And we've got a quote here about New Jersey. New Jersey abolished the death penalty in 2007. Prior to abolition, New Jersey's version of the aggravator required, quote, in the commission of the murder, the defendant purposely or knowingly created a grave risk of death to another person in addition to the victim. Such a link between acts may be, quote, established based on the defendant's intent and knowledge of the risk and the endangered person's proximity in time and place to the murder. The Supreme Court found the shot at Isabel alone to be, quote, powerful evidence of Sosa Hurtado's state of mind towards Isabel. Next, there, quote, was a close causal connection between the shot at Isabel and the shots at Stephen because the evidence, quote, could reasonably sustain the conclusion that Sosa Hurtado shot at Isabel to get him out of the way. Finally, the shootings took place in a small area and the victims were within, quote, a couple of feet when Stephen was shot. These facts led the Utah Supreme Court to conclude that, quote, the killing and the initial shot at Isabel were part of a series of concatenating events, or in other words, that Isabel was within the zone of danger when Sosa Hurtado killed Stephen. Now, the state used this zone of danger. We heard that. The zone of danger from the crowd, the zone of danger from people behind, the tent, the guy standing in front of him, the people standing next to him. But if we go through this three-part thing, it has to be close in time, it has to be close in space, and what extent the third party was actually threatened. Just projecting here, if there was only one bullet, there was one, that's it. There was no distance between a shot and another shot, or a shot and a shovel, or a shot in a car, or anything like that. The spatial relationship, I could kind of see that, but it talks about whether and to what extent the third party was actually threatened by the assailant, either by direct threats or by indirect means, stray or ricocheting bullets. There were no other bullets fired. I see what the defense is saying here. The evidence presented by the state fails to establish probable cause as to the KGRD aggravator. Preliminarily, Mr. Robinson must alert this court to a significant problem presented by the state's argument as to the facts established at the preliminary hearing. The state makes little effort to distinguish between the evidence presented, and the inferences it asks this court to make based upon that evidence. Rather, the state pursues an unconstitutional expansion of the KGRD aggravator to this case and fails to distinguish reasonable inferences from speculation. As the Utah Court of Appeals explained early this year in State v. Murphy, a magistrate may deny bind over, quote, when the evidence considered under the totality of the circumstances is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. In other words, quote, a magistrate may properly deny bind over where the facts presented by the prosecution provide no more than a basis for speculation. Quote, the line separating speculation from reasonable inference can at times be faint, end quote. The two are distinct. Quote, an inference is a conclusion reached by considering other facts and deducing a logical consequence from them. Kind of like what we just went through at the 1, 2, and 3. And speculation entails, quote, the act or practice of theorizing about matters over which there is no certain knowledge at hand. In short, the difference between an inference and speculation depends on whether the underlying facts support the conclusion. Now, remember, when we started this, they specifically talked about that the magistrate can infer, but they can't speculate. And they talk about knowledge at hand. We see the state going to town in their brief about the number of bullets, about the distance, about the target practice and stuff like that. But I really don't remember that unless I missed something from the preliminary hearing. We didn't hear about why there were 4 rounds. We didn't hear about intent to take out Charlie's supporters. We didn't hear anything like that. They're talking about, the defense is talking about the evidence. What evidence did we see? And inferences. But what evidence did we see? We didn't see a note saying, I'm going to use these 4 bullets to take out 4 people. He talked about Charlie, right? Again, I'm just asking these questions here. Furthermore, it is not appropriate to stack inference upon inference to satisfy an element of the offense. That would be like there were 4 bullets, maybe he meant to hit 4 people, and then he was that's, speculation and inference. It says, while inferences drawn from facts and evidence are appropriate, inferences drawn from inferences are not, end quote. State v. Cristobal. And when evidence supports more than one possible conclusion, none more likely than the other, the choice of one possibility over another can be no more than speculation. Let's take that quote right here. Did he have 4 bullets just to fill the gun? That maybe he thought there would be a shootout down the road. Remember, it has to be temporal. It has to be at the same time and within close distance. Maybe he thought he needed more going home. Maybe he thought there would be a chase and there would be a shootout. Maybe he just liked, because he wrote on the bullets, allegedly, whoever, all the bullets meant something. Maybe the bullets were put in there randomly to see which one ended up being the one. Those are possible conclusions. Those are inferences, things we can think about. And they're saying here, When the evidence supports more than one possible conclusion, the choice of one over the other can be no more than speculation. They're saying you can't have speculation. The following is a recitation of the evidence presented at the preliminary hearing specific to this court's determination on the aggravator and the state's arguments regarding the aggravator without drawing inference upon inference as the state asked this court to do. Let's see if we heard about the number of bullets, about the ricocheting and the target practice and all that. This is what the state said. I don't know if it's verbatim. It says it's a recitation. The afternoon of September 10, 2025, quote, several thousand people gathered in and around an amphitheater on the UVU campus to watch and listen to guest speaker Charlie Kirk. At 12:28 p.m., Mr. Kirk was struck by a projectile on the left side of his neck, and the injury resulted in his death. The best evidence of the events on September 10th, 2025 on the UT Valley campus are the videos. I'm going to go back to that in a minute. States Exhibits 12.1 and 12.4 are compilations of UVU surveillance footage from September 10th at 05:33 of 12.1 and 12.4. The surveillance depicts the roof of the Losi building and the walkway between the Losi building and the computer science building beginning at 12:20 p.m. I got to make a timeline for this, folks. This is a little crazy. At 016 of 12.4, they're saying it's not a time, it's a playing fast forwarding. At 6:18 of 12.4, the shooter is seen going over the railing separating the walkway from the Losi roof. Bagley said, quote, a little guardrail probably about a couple feet high, end quote. Each of the videos then jump to 12:22:12. That's a jump of about 7 minutes. When a figure is seen running west across the Losi roof. At 12:22:25 p.m., the figure drops to the roof and begins to crawl to the western edge of the roof, going both south and west. The shooter reaches the edge of the roof at approximately 12:22:44 p.m., although additional body positioning on the ground is visible until approximately 12:22:56 p.m. See also describing evidence of, quote, prone position in gravel on rooftop. Agent Hull testifying the shooter was prone for 15 to 30 seconds. At 12:23:28 p.m., the figure gets up and begins running to the northeast corner of the roof and drops off the Losi building roof to the ground. Officer Bagley observed a shoe print in grass where an individual observed jumping from the roof. Exhibits 12.1 and 12.4 show the shooter was in position on the southwest corner of the Losi Center roof for approximately 35 to 44 seconds. Officer Bagley testified that, quote, there is a clear line of sight between the tent and the top of the Losi Center. Exhibit 7 depicts the shooting of Mr. Kirk from behind the individual, asking him questions, quote, questioner, immediately prior to the shooting. The questioner is separated from Mr. Kirk by a barrier, a patch of grass of unknown dimensions, a table, and the space behind the table in front of Mr. Kirk. They're probably trying to get that first thing about the second thing about proximity. Mr. Kirk is sitting on a chair on an elevated platform that is centered in the backdrop. The shot occurs at 00:32 of this video. There is one individual seen to Mr. Kirk's right and behind Mr. Kirk under the tent. This individual is on the opposite side of where the bullet struck Mr. Kirk. The video has no timestamps. State's Exhibit 8 begins with Mr. Kirk in the courtyard throwing hats to members of the crowd. The video has no timestamps. Beginning at 00:32, State's Exhibit 8 depicts Mr. Kirk seated at the table under the pop-up tent with the same questioner visible in front of Mr. Kirk. There are what appear to be 2 security personnel in front and diagonal to Mr. Kirk, standing in the grass area by the barrier seen in Exhibit 7. The camera recording Mr. Kirk is visible above and behind Mr. Kirk in State's Exhibit 7, meaning the camera is angled downward. The shot occurs at 00:48 in this video. One of Mr. Kirk's security guards come into frame from the right of Mr. Kirk 3 seconds after the shot. State's Exhibit 9 is UVU surveillance footage from behind the pop-up tent that begins at 12:21:14 p.m. The moment of the shot occurs at 02:13 in the video. Confirmed in testimony from Agent Hull, No one is immediately behind the center of the, quote, American comeback pop-up tent when the shot occurred. It is also self-evident from this video and States Exhibit 7 that no one can, quote, see through the back of the pop-up tent. Remember these questions at the preliminary hearing. They were talking about what was going on with the pop-up tent. Now we know why it's see-through or whatever. Agent Hull testified that he, quote, can't answer what would have been visible to the shooter on the Lucy Center roof. Finally, States Exhibit 6 depicts 22 seconds of the event from the perspective of witness AW. There's no timestamp on the video, but based on the content, it appears to be taken close in time to when Mr. Kirk initially sat on the elevated platform under the pop-up tent. I don't know what they're getting to here. They're going on this tangent here. The state's forensic investigator, Agent Jennifer Fomina, testified that the distance of the slope between the rooftop vantage and the pop-up tent was, quote, approximately 415 feet. Agent Fomina also testified that the elevation difference between the bottom of the amphitheater and the low-sea roof was approximately 68 feet. Finally, Agent testified that the distance without consideration of the slope between the 2 points was 410 feet. A Mauser model, I wish they would make their point in between these sections. A Mauser Model 98 rifle was recovered in a wooded area across the street from the northeast corner of the Locy Center where the individual ran after jumping from the roof. The rifle was a .30-06 caliber with a scope. The rifle was a bolt-action rifle. In order to, quote, load it, lock it, as well as extract anything that's in the rifle, the user has to manipulate the bolt. When law enforcement manipulated the bolt, the rifle had a, quote, fired cartridge case inside and 3 unfired cartridges, end quote. It wasn't like whoever racked it back, loaded another round, and was going to take another shot. They're focused on it has to be multiple shots, multiple damage, multiple attempts where somebody's going to be injured. They're pointing out here that there was only one. States Exhibits 12.1 and 12.4 also contain video of an individual the state's witnesses identified as Mr. Robinson entering and exiting campus parking structures, quote, 4 times on September 10, 2025, twice before the shooting, once at the time of the shooting, and once after the shooting. A vehicle was seen matching Mr. Robinson's on campus. The first entry was at approximately 8:30 a.m. with an individual state's witnesses identified as Mr. Robinson returning to his vehicle at approximately 9:25 a.m. Agent Hull testified that during this initial visit, Mr. Robinson went to the amphitheater and spoke to, quote, some representatives from TPUSA. The second entry was at approximately 10 a.m. and Agent Hull testified that Mr. Robinson went to Chick-fil-A in the Sorensen Center, walked to a wooded area across Campus Drive, and appears at the railing on the walkway between the Computer Science Building and the Locy Center roof. Mr. Robinson left campus the second time, quote, just prior to 11 a.m. The individual identified as Mr. Robinson is next seen returning to campus in different clothing and walking with, quote, a limp at 11:53:05. According to Agent Hall, the individual he identifies as Mr. Robinson is seen walking in a parking structure in front of the Locy Center and then on the walkway between the Computer Science Building and Locy Center at approximately 12:15. None of the footage shows the individual identified as Mr. Robinson passing by or near individuals that are clearly minors. One of the aggravating factors is the children under 14. A search was later conducted of the residence Mr. Robinson shared with Lance Twiggs in St. George, Utah. In the closet on the 4th floor of the apartment, law enforcement found, quote, some shooting targets with perforations on it, end quote. Agent Fomina testified, I remember that now. Agent Fomina testified that the perforations were consistent with bullet holes. The targets show perforations outside the target, closer to the target, and then even closer with a perforation in the center. The communications the state admitted between Mr. Robinson and Mr. Twiggs indicate Mr. Robinson's intention to kill Charlie Kirk. Quote, I had the opportunity to take out Charlie Kirk and I took it, end quote. There's no mention of any threat or intended harm to any other individuals. The state quoted liberally from the medical examiner's report admitted as States Exhibit 11 in its public filing. Yes, and I was surprised by this. Despite the exhibit not being published and medical records being categorically private under Utah Rule of Judicial Administration 4-202.024N. I was surprised by that because remember, we got precluded from seeing that. This appears to be another example of the state publicizing private information in contravention to the rules guiding record classification. It would have been a simple matter for the state to redact this private information. And they quote Mr. Sturgill saying, "This is a document that does contain very sensitive information and the information that Mr. Kirk's family would appreciate not being published. We'd ask that it not be published in the courtroom or to the camera." Yes, I was shocked. That was in the state's, what are we calling this? Brief. State's Exhibit 12.1 shows, quote, zoomed in portions of State Exhibit 12.4. 12.1 was received into evidence and played in the courtroom, but not published to the cameras in the courtroom. We didn't see that. So they're talking about stuff we didn't see. Officer Bagley testified that the Low C Center has 4 or 5 levels, with level 1 being courtyard level, and the top level has an atrium on top of it. The state claims in its brief that, quote, at least 2 individuals were standing under the tent where Mr. Kirk was seated. This claim is contrary to the evidence and is indicative of the state's reckless recitation. We always have the alliteration, don't we, of the evidence in its brief. All right. The state did not show footage of the individual identified as Mr. Robinson's movements in and around campus during the hearing, only footage from the parking structures. All right. This court must reject the state's asserted theories as to how it has established facts supporting the KGRD aggravator because it has failed to establish the facts that are constitutionally required. We're still on this aggravating factor. The state offers 2 interrelated theories of KGRD that fail to conform to the criteria established by the Utah Supreme Court, criteria which, if not met, render application of the KGRD aggravator violative of the U.S. constitutional amendments. Each is just deconstructed here, and the Utah Constitution. First, the state has propounded a, quote, line of sight theory, which is based upon out-of-state authority that has never been adopted in Utah. They talked about those older cases and not in Utah. It says it is primarily based on the decisions of courts in Pennsylvania before that state enacted a moratorium. And it says for over a decade, Pennsylvania has had a moratorium on the death penalty. Moreover, the state's reliance on this authority fails to support the application of a, quote, line of sight formulation to the facts it presented at the preliminary hearing. The state's, quote, line of sight theory as applied to the, quote, questioner to the east and below Mr. Kirk fails based upon the facts the state presented to this court, and no further reasonable inferences based upon those facts can support that basis for the aggravator. They're saying that the line of sight theory fails and that there's no reasonable inferences to get there. Because remember, the magistrate can infer, but he can't speculate. The second theory is an, quote, everyone near argument, which relies upon only one of the factors identified in Sosa Hurtado and ignores the other 2 factors which are not present here. Moreover, the state asked the court to speculate about the shooter's knowledge. Remember, they can't speculate. Even assuming that one can infer a knowledge of some risk to the shooter, the state has failed to show that the actual conduct created a, quote, high probability that someone other than Mr. Kirk would be killed, and thus this theory fails as a matter of law. Where there were people in some proximity to a discharge of a single projectile from a precision firearm in a high-powered scope, making it easier to be on target, is what I feel like they're saying. Again, we don't know. Which the evidence establishes hit its intended target. The single factor of proximity fails to permit an inference of a subjective knowledge of the shooter of a high probability of risk of death to others. Remember, they need all 3. Where no other person was injured in a manner creating great risk of death and no other shots were fired, the allegation of KGRD aggravator cannot be sustained. Line of sight. The state broadly argues that certain individuals were in the shooter's, quote, line of fire. There are two fatal flaws in the state's argument. One is factual and the other is legal. Factually, the, quote, line of fire assertion as to the questioner defies logic. The evidence established that there was one shooter on the roof of the Losi Center. Mr. Kirk was seated under a pop-up tent in the center of a courtyard to the southwest of where the shooter was positioned on the roof. The single shot fired traveled from east to west at a downward slope into the bottom of the bowl where the tent was located. State's Exhibit 7 shows the vantage behind the questioner prior to and at 12:23:28 p.m. The questioner is in front of Mr. Kirk to the east. If the questioner had been in the line of fire from the bullet moving towards Mr. Kirk, the questioner would have been struck by the bullet as it traveled. He would have had to been, I don't have my north, south, east, west, but I believe he would have had to been over here because it was going this way, right? In fact, the state's evidence shows exactly why the questioner was not in the line of fire. The single bullet came from above. The video evidence shows that Mr. Kirk was seated on an elevated platform and separated from the questioner by a security barrier, a grassy area, and then tables that surrounded Mr. Kirk on three sides. We're going from this to this. The bullet traveled at a downward angle and hit Mr. Kirk in the left side of his neck. Where Mr. Kirk's head neck area was elevated and an unidentified distance away from the questioner, certainly more than a few feet away, the only evidence presented supports that the bullet traveled above, not through the crowd. This court must also reject the legal theory behind the state's factual argument. The state asked this court to adopt its interpretation of out-of-state authority on a, quote, line of fire theory. However, a thorough examination of the cases which construct a, quote, line of fire theory are not as the state suggests and support that this court should not expand Utah's KGRD application. In Commonwealth v. Watson, the Pennsylvania Supreme Court considered the application of Pennsylvania's grave risk aggravator to a case in which Watson fired 3 shots into an occupied car, striking an individual twice. Watson then shot the lock off the door of a home, pulled his ex-girlfriend from the closet where she was hiding with her 2 children, and shot her twice. He then reloaded, left the room, returned, and then shot her again, and then shot himself. One of the shots lodged in the doorframe around the closet where the children were hiding but did not hit them. Under these facts, the Pennsylvania court affirmed a jury's finding as to the KGRD aggravating factor because the children in the closet were endangered by his conduct. In Sylvia v. State, the defendant argued that there, quote, was not competent substantial evidence to support KGRD because the gunfire was intended only for one person. The Florida Supreme Court disagreed because Sylvia engaged in, quote, indiscriminate shooting in the direction of at least 4 persons other than the intended victim, who were not only put in an immediate present risk of death, but were also in the line of fire, end quote. One of the other individuals was shot and the defendant, quote, pumped the shotgun and aimed it at 2 others. The court explained, "We therefore conclude there was competent, substantial evidence that Sylvia's actions created a great risk of death to many persons. He approached the house while pumping shells into his shotgun. Pellets hit one of the cars in the carport, different locations in the carport, and the door from the carport to the house. Pellets were found inside the house, in the kitchen, dining room, and bedroom. There were 6 unarmed people in the carport and house when Sylvia approached, shooting and pointing the gun at people." It says here, the state calls this, quote, a few feet in its brief, but there was no evidence of the distance submitted to the court. We don't know how far that, I think they're talking about that by the questioner. It says the video shows the distance and speaks for itself. In Commonwealth v. Reed, the Pennsylvania Supreme Court found sufficient evidence to uphold the, quote, grave risk aggravating circumstance. Reed had fired multiple gunshots at fleeing children after chasing them in his vehicle. One of the shots hit a young man in the back, killing him. Less than a week later, Reed killed another individual with the same weapon. The court noted that, quote, 12 to 14 others were in the line of fire when Reed, quote, chased the boys while driving his car and, quote, gunfire flashed from the windows of Reed's car, killing the first victim. In Commonwealth v. Buck, the court considered whether the Commonwealth's notice to the defendant of the aggravating circumstance was sufficient, and if the Commonwealth abused its discretion in proceeding on 3 aggravators, one of them, quote, grave risk. In finding the Commonwealth did not abuse its discretion in alleging, quote, grave risk, the Buck court found that evidence raised a factual question for the jury because, while only one individual was shot and killed, the potentially endangered person stood behind the decedent in a bathroom and, importantly, because the endangered person wrestled with the defendant over the gun after the shot was fired. In State v. Wood challenged the application of KGRD in a double murder case where he did not shoot any persons other than the victims and there were no bystanders in the line of fire. The court found that although the defendant's argument had merit, the interpretation of KGRD proposed was too narrow, quote, under the unusual facts of the case. The Wood court found, quote, no single factor is dispositive of KGRD, and the inquiry turns on, quote, whether during the course of the killing, the defendant knowingly engaged in conduct that created a real and substantial likelihood that a specific person might suffer fatal injury. Thus, several factors, quote, in combination supported KGRD. There was the presence of others. The defendant turned to another, and it appeared if he was going to shoot a third individual. Another employee fought defendant over the gun, and there was evidence the defendant, quote, knowingly prepared the gun to fire when he assumed a shooting stance towards one employee and then he grappled with another. None of these cases support the state's position here. Each involves conduct directed at the endangered person, consistent with the Utah Supreme Court's endorsement of the 3, quote, zone of danger factors in Sosa Hurtado 2. In determining if KGRD applies as a matter of law, this court must consider if any conduct constituting a great risk of death was directed at any individuals other than the victim. Here, there is none. Utah has never adopted an interpretation of KGRD that would permit its application where the firing of a single shot at an intended victim that hit only the intended victim merely because other people were in the vicinity. Nor does the state's reliance on an out-of-state authority in which personas other than the decedent are targeted and or injured support this proposition. As a matter of law, the court cannot bind Mr. Robinson over on this theory of the KGRD aggravator based on the facts presented by the state. What they're saying is they've had no challenges or anything about a single shot that was meant for one person, hit only the one person, just because people were there. And it talks about, nor does Utah rely on the out-of-state authorities, those cases where other people are targeted. They're saying you can't do it on that. This is a lot on these aggravating factors here. I'm going to end this video now. I'm going to continue on to a part 2. Thank you for being here. Please put your comments below, and I will see you on the next one.